Welcome to Fasken's 14th consecutive mining series. My name is Virginia Schweitzer. I'm part of the Fasken Global Mining Group and also the co-managing partner of Fasken's Ottawa office. Today's hybrid seminar is a mining in the era of consent. It is the 11th of our series of 14 seminars this year. A calendar of Fasken's PDAC events can be found underneath the video window for our online audience. Also for our online audience, please refer to the slide on your screen for some housekeeping items. Before we begin, I would like to provide a land acknowledgement. At Fasken, we have embarked on a journey of reconciliation, guided by our Reconciliation Action Plan. As part of this journey, we believe it is important to acknowledge the land and the people that have called this land home since time immemorial. Today, in Toronto, where the PDAC conference is being held, we are gathered on the territory that has been the home of many nations, including the Wendat, the Anishinaabe Nation, the Haudenosaunee Confederacy, the Chippewa, and the Mississauga of the Credit First Nations. Toronto is also covered by Treaty 13, signed by the Mississauga of the Credit and the Chippewa. We appreciate living and working here and recognize the importance of working to advance reconciliation between Indigenous and non-Indigenous people here and across Canada. Now, I will turn it over to my colleague, Dani Bryant, partner in our Vancouver office, the moderator of today's session, who will introduce today's panel. Dani?
Thank you, Virginia. And thanks everyone for attending. As Virginia mentioned, my name is Dani Bryant. I'm a partner in our Vancouver office, and my practice area focuses on Indigenous environmental and ESG law for in the mining area, as well as other natural resources. We're really excited to have you. I'm especially excited because we've got a fantastic panel joining me today. First off, Emilie Bundock is a member of our mining group and provides advice to clients on a range of environmental, Indigenous, ESG, and corporate ethics issues. And Emilie sits on the board of the Association d'Exploration Minière du Québec. My French isn't that great, but I try. Next up is Zach Romano. He's also a partner in the Vancouver office of Fasken. And Zach has a corporate commercial practice where he focuses on mining and other natural resource development. But Zach also has a particular focus on all types of agreements with Indigenous groups. Zach was recently named one of Business in Vancouver's 40 Under 40 and a Lexpert Rising Star. He's one of our stars. And he's also a Métis, descendant of the historic Métis community at Lac Saint Anne. And finally, we have Norm Fraser with us. Norm is the Senior Leader, Indigenous and Community Affairs with Teck. And he's Fort Chipewyan Métis and mixed European ancestry, and lives and works in Tunaha territory in southeastern BC. He has worked in the interface between Indigenous peoples and resource development for 20 years, including 9 years with the Tunaha Nation, and now 11 years in Indigenous affairs and social performance with Teck. He's currently the engagement manager for Teck's Fording River Extension Project, a proposed extension of their existing steelmaking coal operations in the Elk Valley. Norm's credentials include a Master's of Business Administration in Indigenous Business and Leadership completed at SFU, and he's currently doing a Master's of Law at Osgoode in Dispute Resolution, which after this session he will be going to, I think. So we're in excellent company this morning for the topic that we'll be discussing, which is mining in the area of consent. We'll discuss the changing regulatory landscape related to implementing UNDRIP and FPIC, and the other expectations and processes that exist outside of the regulatory requirements, as well as ways to get to consent. So to get us started, for those in the room who aren't aware of some of the background here in Canada, I'll be quick, but the United Nations Declaration on the Rights of Indigenous Peoples is a UN declaration that reflects international aspirations regarding Indigenous rights, including standards of survival, dignity, and well-being of Indigenous peoples. And a key concept of the declaration is the concept of free, prior, informed consent, also known as FPIC. So those terms will be used a fair amount this morning. Canada was originally one of 4 countries that voted against UNDRIP. However, in 2010, Canada officially endorsed it as an aspirational document. And then in 2016, Canada endorsed it without reservations, which signaled the kind of shift in political will with respect to UNDRIP. And so to get us started, since 2016, and focusing obviously on the mining context, what's the status of implementation of UNDRIP in Canada? And what are the legal or informal requirements or processes for seeking consent throughout the country? Zach, maybe we'll start with you and then we can go to Emilie and then Norm.
Thanks, Dani. Good morning, everyone. So just to start out, maybe I'll start in BC, biased because it's 5 in the morning there, but it's 8 in the morning here. But both BC and Canada have passed legislation to provide a framework for implementing UNDRIP. BC legislation is known as DRIPA, and it became law on November 28, 2019. DRIPA does 3 key things. It affirms the application of the UN Declaration to the laws of BC without delay. It requires BC to ensure that all, and I say BC, the BC government, the provincial government, to ensure that all laws are consistent with the UN Declaration and to prepare an action plan on its progress. And additionally and uniquely, it creates the opportunity for joint decision-making, consent-based decision-making agreements with Indigenous governing bodies in the province. Now, these decision-making agreements could be one of various forms. They could be a straight-up consent-based decision-making process. They could be a collaborative management process, or it could be what we call joint decision-making. But the important thing is they require a mandate from cabinet in order to begin the negotiation process. And so far we have a few examples, most notably 2 recent. First in 2022 with the Eskay Creek mine in Northwest BC, and the second with the Red Chris mine in BC as well. And those agreements are with the Tahltan. And importantly, they've paved the way for consent-based decision-making that has to happen before key permits are issued in order to facilitate development. At the same time as we have that statutory context where decision-making agreements are being negotiated across a province with certain Indigenous nations, the Mineral Tenure Act in BC is undergoing reform as well to allow for additional consultation before mineral claims are staked. Recently, and somewhat controversially, the Land Act, changes were being proposed to the Land Act, which contemplated consent-based decision-making on Crown lands. For those in the room who are, I think, hopefully somewhat familiar with BC, the majority of the province isn't covered by treaties. So we've got asserted claims with nations who have either not yet had a chance to hear their case in court or haven't entered into a treaty, which complicates decision-making on Crown lands, requires the government to consult before it makes permitting decisions. And that context, many parties were saying, required time to think through. And what the government said at the end of the day was the proposals were significant. The feedback they got, quite frankly, there was some blowback due to the short time frame of the consultation process. And that resulted in the province, for the time being, deciding not to proceed with the amendments at this time. The election always has something to do with it. In Ontario, since 2012, there's been portions of the province here that people in the room will know are off limits to staking. Informally, permits aren't being issued in certain contexts unless consent can be evidenced. You're not going to find legislation that sets that out, but that's their experience of proponents on the ground. With that context, maybe I can hand it to Emilie.
Yeah, sure. So thanks, Zach. So as you can all see, BC was a trendsetter in implementing UNDRIP in Canada. The federal government followed just after in 2021 with the federal act implementing UNDRIP, so the United Nations Declaration on the Rights of Indigenous Peoples Act, similar to the BC law. The purpose of the federal act is similar to BC's. However, it refers to the federal crown and federal government. And so it is to first affirm the UN declaration as an instrument that can help interpreting Canadian law. And also it sets three distinct obligations for the federal government. The first being to take all measures necessary to ensure the laws of Canada are consistent with the UN declaration. Then to prepare and implement an action plan to achieve the objectives of the UN declaration, and to develop annual reports on progress and submit them to Parliament. So we've had some work done by the federal government in collaboration, consultation with Indigenous groups across Canada for 2 years that led to the first action plan for 2023 to 2028. That contains a fair amount of measures, like almost 200 measures are included in the action plan. Most of those measures for the time being, so for the first action plan, relate to Crown Indigenous relations. Not many relate to, let's say, a proponent Indigenous group's relation, except the idea that there are actions that should be directed to amending the Impact Assessment Act to introduce the concept of free, prior, and informed consent in the impact assessment process at the federal level. So how this will materialize in practice still remains to be seen, but we could see something similar to what we see in BC with the decision-making agreements, for example, that would foster or advance consent in a various decision-making process with respect to major infrastructure projects, natural resources developments, and so on. The upcoming changes to the Impact Assessment Act that are probably going to be in the next budget that Minister Freeland's going to table on April 16 will likely not include amendments to the Impact Assessment Act focusing on this particular measure, because the focus now is really to respond to the recent Supreme Court reference case about the constitutionality of the Impact Assessment Act. But I think we will see, in a let's say medium, like not short term, but sometime we'll see those amendments to incorporate at least a level of FPIC in the Impact Assessment Act. I'll move to the province of Quebec for a short, let's say, comment on the status of UNDRIP in Quebec. So unlike the federal government and the BC government, in Quebec, we don't have a law that's actually implementing UNDRIP. It looks like Quebec courts or maybe have an opportunity to look at UNDRIP and to see how UNDRIP can be a tool, an instrument to actually interpret Canadian and Quebec laws. There was a recent Quebec Supreme Court decision rendered in December of 2023, where Justice Bourque actually found that the adoption of UNDRIP into Canadian law raises new legal issues that would justify revisiting the test for Aboriginal rights, so the Vanderpeet decision test, because she feels that UNDRIP has to inform the way that we interpret Section 35 of the Constitution Act, 1982. And so the court specifically said that it wanted to prevent UNDRIP from becoming an empty shell, and that the Canadian government has already shown a clear willingness to comply with it by the adoption of the Federal Act and also the adoption of the BC Act in BC. And so the way she's revisiting the test is really focusing on identifying the collective right, proving the right is protected by their traditional legal system, and showing that the practice or activity in question is an exercise of that right. And so it's a lighter, let's say, it's a lighter test. So it's easier for Indigenous groups, and especially in Quebec, because as you know, the date that you need to go back in Quebec is much, like it's 40, 100 something years and plus, compared to BC, where it's more recent history. So the volume and the access to the evidence is, in a sense, much easier when you go west than if you're on the eastern parts of the country. So by focusing on some other aspects of the traditional legal system, she's kind of lightening the test. It's the second time in recent years in Quebec that there's actually courts making steps to adopt or support a larger framework for reconciliation. And so there was the recent reference about the Act respecting First Nations, Inuit, and Métis children, youth, and families, where the Supreme Court of Canada upheld the Quebec Court of Appeal decision affirming Indigenous communities' jurisdiction and right of self-government in relation to child and family services. So the Supreme Court did not focus on the right to self-government, but the Quebec Court of Appeal did. And so, we'll see how those decisions can actually influence maybe the Quebec government and other provinces and the federal government in how they interpret UNDRIP in Canada. I'll pass it to you, Nora.
Okay. So what I would add here is, I guess what we're hearing from the rest of the panel is it's a new space for Indigenous governments, for federal, provincial governments, but also for proponents and regulators. And everyone's really trying to sort of figure it out as they go. Within their organizations, I'd say, there's different perspectives on what UNDRIP means and what FPIC means, but also individuals within those organizations have different views as well. And we're all sort of trying to navigate this evolving landscape. What we're seeing, particularly in BC, with some of the newer environmental assessments, things are proceeding quicker than policy or regulation. So we've seen already a couple different projects go in, as one example, going into dispute resolution processes before there's regulation to guide those processes. So it's I think what we're going to see is it's continue to evolve, and the landscape's going to continue to move as projects are going through the process. So what that means for proponents, I think, is you have to, as much as you're looking and asking for certainty from regulators and from governments, it's also, I think, your responsibility to be thinking proactively and coming with ideas and solutions on how to navigate this new space.
So it sounds like there's a lot of momentum heading in this direction, but that it's not necessarily one clear path. There's lots of different directions it's going, and that everyone's trying to figure things out. So then how does this work in practice? How do you engage in consent seeking and consensus seeking on the path to getting consent? And how do you navigate these new regulatory requirements, norms, particularly in the space where you said where it's not necessarily fully fleshed out yet how that will take place? Maybe we can start, Norm, with you.
Sure. Yeah, and I think people have heard this before, but the key is early engagement. There's a lot to the strategy, but you need to be working as early as possible to help people understand the project and the process that you're going to be going through. So I think of three components to this strategy. The first, of course, is that early engagement, and you have to think more about it's not just sort of getting out there and engaging. There's two elements that I think of, and that's the quality and quantity. So, are you getting out enough, and are you talking about the important things? In the past, perhaps a robust consultation record of a number of emails and missed calls might help you, but that's certainly not the case anymore. You need to demonstrate that quantity and quality, I would say. Second, the second element of this strategy is the relationship, building the relationship. So I would say that from that engagement, the result that you're looking for is a relationship, and that relationship, in my mind, focuses on three things: understanding and mitigating or minimizing the impacts of the project, sharing the benefits, and making fair decisions. So if you have the relationship, those are the things that you need to be talking about: how you're managing impacts, sharing benefits, and making fair relationships. And the result out of those relationships that we're looking for and that we're talking about today is that trust and consent. If I would say if you've done those, sort of follow that, it seems maybe too simple to say, but if you follow sort of those three steps, then consent is the result of that work.
So, what risks, Zach and Emilie, do, or maybe we'll focus on Zach first. What risks to a project currently exist in this new framework, in this new regulatory context, and how can a proponent mitigate those risks?
Maybe just to put a bit of context and a bit of detail, I'll put it in the context of the Environmental Assessment Act in BC, and thinking about how that looks with respect to consensus seeking. And so in BC, we've got the Act, which contains statutory requirements for consensus seeking and consent seeking with participating Indigenous nations, they're called, at particular decision points. Now, participating Indigenous nations are the nations that are self-identifying to the Crown in advance of the EA, which the Crown then confirms are the nations that will participate in the EA. What used to happen is there was a strength of claim analysis that would be done and a process order would be issued, but now it's essentially self-identification coupled with confirmation from the regulator. There's 5 key points of decision-making where consensus seeking is sought. And that's first at the readiness decision, it's called, and that's with respect to whether a project should in fact proceed to an assessment, be terminated or exempted from an EA altogether. There's another step called the process order, and that's where the scope of the environmental assessment is actually laid out. What types of information are going to need to be addressed, who's going to participate, what's the timeline, what's the assessment plan. An additional step where consensus is going to be sought is the application, assessment, and review stage. And that concludes when the regulator determines an application is in fact complete and ready to support an effects assessment. Additionally, there's the actual effects assessment, which is where the EAO has an assessment report and it makes recommendations about how to mitigate impacts as well as how to address those impacts through condition. And the final consensus seeking step is the referral to ministers for their approval decision. Now there's 2 consent points as well. The consent opportunity for nations to identify whether they consent to a project being exempted from an EA or whether an EAC, the environmental approval should be issued at all. And within that context, one of the key questions for proponents is, well, what does consensus seeking mean? And that's not defined in the legislation. So we then end up with this potential risk for delay, which is ultimately could be a project killer with respect to when a decision is ready to be decided upon. When is enough consensus been sought? When does the timeline stop? There's reference to obviously the legislative timelines that may exist, but there's opportunities to pause throughout the process. And so with that context, if delay is the primary risk, there's others, but for a lot of clients, the delay being the primary risk due to uncertainty in the legislation, proponents are finding, and the successful ones are finding, that the agreements you can enter into with nations in advance of your EA to actually formalize those expectations about the process, fill in the blanks of what consensus seeking means. To Norm's points, figuring out ways to get mutual alignment on what fair decision making looks like. What does consensus seeking look like? What are the timelines? Additionally, it's looking at how to really find ways to keep the issues you can resolve bilaterally out of public view and dealt with appropriately in a way that doesn't force nations into a process where they have to defend themselves in a regulated process in front of the Crown. And at the same time, it's creating alignment. I think there's ways that proponents are finding ways to create alignment with nations beyond simply, formalizing a capacity funding agreement. It takes various forms. There's joint submission of letters. There's joint authoring of documents. There's attending meetings together. All these types of things start to evidence that you've got an actual relationship where you're not at each other's throats in the room. Nations aren't holding you to pay capacity funding that should be paid and you're refusing. Those table stakes issues just get ironed out and things become much easier. And lastly, and a good point, we were talking about this yesterday, but from our experience in BC particularly, seeking confirmation from the government as to what they expect. What does consensus seeking look like to them? And Norm touched on that. And again, maybe biased because we're agreement lawyers, but finding ways to make sure your agreement, the bilateral agreement with the nations, can address those expectations and interests of the Crown.
Thanks, Zach. Norm, maybe you could touch on, in practice, what that means. What do these requirements for and expectations for consent mean in a proponent's ability to develop a project, and how do you practically address those risks that Zach mentioned?
Sure. I think this is really sort of follows some of the points that Zach was making. And so I talked earlier about the importance of early engagement and relationships. And actually, I'd like to frame all my answers with 3 points. So again, there'll be 3 points in this one. The first, the relationships and early engagement. So you can't be surprising Indigenous governments or people with your request for consent. The other participation that you're looking for in the regulatory process, has to be known and anticipated. So that's point number one. The second, and Zach mentioned this a little bit too, collaborating on the process. So you need to be working together. You need to develop ideally portions of the application and the assessment together. You're working together on what the potential effects are, what appropriate mitigations are. I think this is also a good example of building your practice, I guess, getting into the practice of agreeing and working through tough issues. So if you can agree on how the process is going to unfold, I'd say you're in a better place to actually agree on the project and get consent for the project. And then the third point that Zach's also mentioned is the importance of agreement. I mean, that's really where you have the opportunity to put all that good work down on paper and have something that's going to be durable and something that you can share with the regulators.
Emilie, do you have anything to add?
Yeah, one thing I'd like to add is very often at the EA stage, the proponent is very much focused on getting the permit for the project. You need to put yourself in a mindset that is more forward-looking, that is more long-term, that will take into account the project as a whole. And when you're looking at a consent-seeking agreement or whatever form of documentation or proof of consensus or consent that you want to put forward, think about what could be also useful for the future. Think about future-proofing your project, cumulative effects that are very important for Indigenous groups when they actually are willing to give the consent for the project. I mean, those things need to be taken into account. And I think we're going to touch on this later, because you're probably going to have to renew the consent at some point. So you better start with a forward-looking mindset. You don't have a crystal ball, so there's a risk of getting into this rabbit hole of like thinking about everything that could happen, and then you get into maybe difficult discussions, but you still need to have the whole project in mind when even at the EA stage.
Norm, you made a really good point just now that it sounds like maybe a way of putting it is that getting to consent is stepwise. It's step by step by step. You don't just leap to consent. You develop the relationship. You build trust to get there. So I'm wondering, what role do agreements play in developing a project? And there's consent agreements, but there's other forms of agreements as well. And so how can you use agreements to increase predictability in terms of your project approvals and achieving investment opportunities and meeting ESG standards and all of those things? Norm, do you want to kick us off?
Sure. Yeah. Yeah, I guess I would start with, as you were saying, it's a stepwise approach. So even the agreements themselves, they have to be viewed, I would say, as a milestone. And really, what you're working for, what the goal is or should be, is a comprehensive and productive relationship. And so, yes, the agreement, the consent points are important milestones, but as Emilie was just saying, you need a productive relationship that's going to be durable beyond that environmental assessment certificate, if that's a good example, through the operation of the project and into closure. You're going to be working with these Indigenous groups for the life of the project, and you have to sort of keep that in mind, that it's a long game, I would say. In terms of ESG, I mean, there's lots of great reasons to do agreements. Of course, formalizing how you engage on environmental matters, supporting the development of sustainable communities where you operate, and I think a key piece of agreements that's probably not used enough is dispute resolution processes. How you inevitably you're going to face disagreements as you go through the process and operate the project, and you need those processes to fall back on to resolve those things as they come up.
Zach?
Yeah, I think thinking about it in the context of the paper is important as well. So we think about consent agreements, and I think in a lot of our view, consent it's clear. We're in an era of consent. Consent's the easiest way to get an approval. The easiest way to evidence consent is through an agreement, but you got to get the agreement right. The form it takes needs to be proper. Building on Norm's advice about 3 points, I've got 3 on that. There's really the first one being you need to have agreement in advance about what form your consent is going to take. You don't want to be renegotiating the paper each time consent is needed to evidence the relationship to a third-party investor, financing transaction, you're in an acquisition, or to try and show a Crown regulator that you've got alignment. Secondly, you need to be able to evidence consent when you need it in terms of the project development timeline. Again, having agreement on when you request, how it's provided, and it being provided in a mutually agreed way that doesn't require renegotiation is key. And thirdly, you need a process, as Emilie talked about and alluded to, for addressing what's sometimes thought about as reopeners, but more and more, it's just about addressing unanticipated changes. So if the scope of your consent is too narrow, the changes that are inevitable for the engineers in the room and others who actually build mines, they'll realize projects change. If your scope of consent is too narrow, it's potentially an issue where you're not going to have consent for full build out of your project or the reasonable adjustments that may need to be made to achieve that goal. So thinking about how you come up with a mutually agreed process for addressing changes when they come up, while making sure you've got enough flexibility to actually build your project at the end of the day is key in terms of the types of agreements that you conclude. Maybe Emilie, I'll pass to you.
Sure. So one thing I'd like to add here, those consent agreements, as we're all saying, are also process agreements that will help you renew consent if there are changes in circumstances that require, that would depart from what your project was actually, how it was described initially, how it's evolved, how it will eventually evolve on over the life of mine. Will you need an amendment to your certificate of authorization, your environmental assessment certificate? If that happens and you need to go back to the regulator, is your agreement still sufficient to evidence consent, or do you need to renegotiate the agreement? Do you already have a process embedded in your agreement that both parties have consented to use during the life of your project? So that is clearly key, because the one thing about consent is when you don't have it. That's clear. That is very easy to evidence not having consent. And the impact of that is also clear and can be very detrimental to your operations, the project, and the relationship with your Indigenous partner, who will be your partner for the life of your project. So those are key elements that can be addressed in the paper. You need the right paper at the right moment, and you need the paper to provide for the right process. And I like Norm's comments on the dispute resolution process, which are very often not the cool things you want to discuss when you're negotiating those agreements. They're like, okay, let the lawyers look at the dispute resolution process. If it's okay from a legal and lawyer standpoint, it should be fine. The parties should also actually appropriate, they should actually feel that the dispute resolution process means something to them, that they can use it. So there needs to be steps in that process as well. Don't go all the way to an arbitration that's going to probably put the people in a more of a no consent situation. There needs to be steps where the parties can try to resolve those disagreements on an amicable terms.
So, Emilie, you raised a good point that you know when you don't have consent. So far, we've talked about how do you get to consent, but what if you don't achieve consent? How much consent is needed to get project approvals, to get a project built in the country? And it sounds like there are different regulatory and contextual requirements right now, but what should a proponent be looking at? How, is there a number? Is there an equation? Is there a way to figure out what consent you need? Zach, maybe we can start with you.
Thanks, Dani. There's I think maybe an easy answer and then a maybe not so straightforward answer. But the example, maybe just to focus on BC again, we have the first gold mine to be assessed and approved under the new BC Environmental Assessment Act, which contains what I've been droning on about today about the consensus-seeking and consent-seeking requirements. In that EA, 3 participating Indigenous nations were involved. At the end of the day, before Minister decided, 2 nations consented. 1 nation withheld their consent. And after subsequent government-to-government discussions, confirmed that they weren't going to consent, but weren't opposed to the project. So within the ambit of the description of consensus and the policy that the province has, it's effectively what we got to. In other projects, which we're involved with and are aware of from other contexts, that are being assessed on our legislation that aren't acts which contain statutory requirements for consensus seeking and consent seeking, in contexts where nations who have established rights have consented, where consent isn't technically in a formalistic way, the legal requirement to be met for an approval decision to be made, where nations are opposed, government decision makers are waiting to be comforted that I think their decision isn't going to harm the relationship with the nation who's holding out. And that's not to say it's going to be indefinite, that they'll not make a decision, but it's clear that there are other factors being contemplated which push us towards consensus-seeking, robust, and really, in effect, potentially consent-seeking consultation processes, even in assessments where the legislation doesn't actually require it. So what is the test to be met before the government can decide in those circumstances? Pretty clear it's not just satisfying yourself that the boxes on consultation on the HIDA test have been checked. It's something else, and it's something more material than what may have previously been expected.
Emilie?
So I would say it depends a lot on where you are in the country. The way that the regulators, on the one hand, will look at is consent required and how much consent is required will vary greatly between, let's say, BC and where I'm more involved in Quebec. Although even in Quebec, we have different ways of looking at consent, and the regulator will look at it differently if you're on the James Bay Agreement territory versus the rest of the province, because they really tie it to Section 35 of the Constitution Act 1982, and so that will inform the way that the regulator will look at, do you need consent, and how much do you need? On the other hand, the Indigenous groups, they much more have UNDRIP in the way that they're looking at how much consent is required. And they are a lot more looking at how much consent is required or is actually obtained in respect of other projects with other Indigenous groups in the rest of the country. So there's a different way of looking at how much consent you need, depending on if you're the proponent, the regulator, the Indigenous group, and depending on where you are in the country as well.
So I would add, the title of the panel here, Mining in the Era of Consent. So in the era of consent, I'd say regardless of where we're at in terms of implementing UNDRIP, the goal now should be consent from all the Indigenous governments that you're working with. So as a proponent, I would say that should be your starting point, and to try to do the math too early is going to be ill-advised. I would say, like, that goal has to be getting the consent from all the groups. And I would go back to my 3 points earlier: the early engagement, the collaborative process, and agreement making. Those are two-way streets, right? Those are where you're learning about the Indigenous government, the aspirations and the perspectives on consent, at the same time as you're sharing your views and information about the project, and through that, through that robust process, the consensus ultimately that you're seeking and that you're going to achieve is that demonstration of the hard work and your respect for the rights of those Indigenous groups.
Wonderful, thank you. So I'm just going to awkwardly walk over to the podium here to see if we have any questions. First off, if you have any questions in the room, you can feel free to ask them. Joyce has a microphone, so just put your hand up and she'll come find you. Yeah.
It's more of a complication than a question. I'm a geologist and I'm just involved in a lot of early stage projects. So I'm not an expert in this field, but I do, participate in presentations if someone wants technical information and that sort of thing. So I see a lot of things like agreements, concepts, all this. But one thing that was often said in the singular was consent. And when I look at a typical thing that I'm involved in, there's about 9 different entities. There's elected leadership, traditional leadership, what the overall community thinks about it First Nation wise, which formal treaty area you're in, what's the nearest community, which isn't necessarily the treaty area, resource users like trap lines and things, which may be related to neither of those. Overlapping land claims, which of course in BC is 300 or 400%. And then, issues with non-First Nations lodges, hunting, fishing things, and non-First Nation communities. So, that's kind of my short list of a typical engagement. and how do you invariably, I don't want to say, invariably a company gets something wrong because someone is offended because they were approached first or maybe better amongst that list than the other entities on that list. And it's a really delicate process. I'm certainly not expert in it. That's not my forte. I'm just wondering about comments with dealing with prioritizing and understanding that list.
That's a great question. I thought we were going to get softball questions, but no, that's great. I guess I would start with understanding that context is critical. That's a part of that early engagement. I would say is you need to know what those different perspectives are. But you also need to recognize who are the decision makers in those communities. So, through the depth of your relationship and understanding those different perspectives, I think you'll identify opportunities to minimize some of the effects of the project for each of those different perspectives, and ultimately sort of package up sort of the best set of mitigations and design for the project. That'd be my initial response.
So I would add again, I think it will vary. There will be various degrees of, is there a process with this group in particular where they already know how to deal with, getting everybody together, seeking consent and formalize it in, similar situations, project development or other, because they've done it with other proponents in other projects. So you'll have that type of context. You'll have other types of context where they've never seen a mining project before. So there's going to be a bit of politics also, sometimes a lot, that will need to be kind of done before you can actually advance with any community meetings or any socialization of your activities. So that will require a lot of adaptation to the circumstances, and a lot of like thinking, more flexibility for especially the timelines. And it's a tricky question because there are so many options, right? But I think thinking of, you'll have to do a bit of your being a politician in the sense that you'll need to get the buy-in from a lot of groups. And so that's something to invest in, the community relations, understanding the players. Is there a local economic development corporation? Is there a mineral exploration board that is for that particular group? So those are key points that will definitely help identifying how, like, the path moving forward.
One just a few additional thoughts would be what's worked well for our clients in the exploration stage is to make sure that they've got advice early to understand what's actually required for what you're proposing to do. Based on that assessment, which nations are affected, what level of engagement would be recommended with those groups, and what's your approach. That's all forming a strategy that you then implement carefully and deliberately. And at the end of the day, rule of thumb that also serves a lot of clients well is never overpromise and underdeliver. And that's hard to do sometimes if you're in the room and you finally got the attention of a counterparty and things are going well, but you're not really sure the context and the lay of the land. So it comes back to the first point, get advice. You've got lawyers at the same time, the regulators. Ask them what their thoughts are and double check their homework. That's usually how our clients protect themselves in those contexts.
I think we have another question.
What's the state of play in the Yukon between YESA and the UN declaration?
We're finding ways to get agreements to, I think, address what's increasing the expectation of the nations that there should be consent-based processes, decision-making reflected, which aren't necessarily statutorily required right now. It's being articulated by nations directly to our clients. Yeah, I'm not sure where they're at in legislative reform, but at the negotiating table, it's on the projects we're on right now. The expectation is we're essentially doing what's already being done in BC.
Are there any other questions from the room? Because I've got a question online. Oh, let's start here.
Yeah, I have one question with two parts, and then a comment about consent after. Well, I didn't know we were in an era of consent, which is good news, probably. But I want to ask any of the panelists about veto, because the Supreme Court said in one of the main cases that Indigenous peoples do not have a veto. So how do you square that with the era of consent? Okay, that's one part. And then the other thing is free entry. Free entry means that anybody with a prospector's license can enter Indigenous land without notice, without permission. And that's happened to our community. We found out at a meeting, I think a couple of weeks ago, when we were given a map, we saw that our community was inside a mell. We didn't know that before we were given that map. Again, no one asked us, no one told us. So again, how do you square or reconcile? I wasn't going to use that word. But how do you reconcile free entry and consent? And I just want to make a comment about, well, consent, how much consent? English is not my first language. but I had a good English teacher in high school. And I think I know what consent means. Either there is consent or there is no consent. There is no such thing, as I understand the word consent, there's no such thing as how much consent. So, and if you could speak louder and into the mic, I'm hard of hearing, so even though I'm wearing hearing aids. Thank you.
Free access first. So I think on the free access comment, I think what we're seeing right now with the case in BC on the mining staking process and Indigenous groups asking for consultation at the staking stage is kind of it's a step to actually shake the free access concept. We have a similar case in Quebec where Indigenous groups are also asking the court to rule on whether or not there needs to be consultation at the mining staking stage. And free access is a concept that is clearly being shaked a bit in those cases. So I think on that, it's one of the indications that we're kind of moving into this era of consent. Like it's a step, and I think it's the consent. Yes, it's consent or no consent, but it is also a process to get to consent, and I think that's part of the journey that we're actually into.
I think veto is a red herring in many ways, and I mean I say that from the basis that when the UN Declaration was being contemplated, the sky was falling. There was a veto, and that prevented progress for quite some time. Now we're to a point where it's clear that under Canadian law, there's processes for consensus seeking in BC and consent seeking in BC that don't grant a veto. Consultation law doesn't grant a veto, but if you're practically trying to build something impactful on traditional territory and the nation is saying no, and they're refusing to consent, and they're the title holder, hard to foresee a world where projects in that context get approved easily or at all. So I'm hopeful we're moving towards a world where we get to consent being more of a discussion about process and outcome in that vein, as opposed to the worry that we're in a world where veto is going to ruin the day.
So maybe, sorry, didn't sound like it was on there, but I think similar to what Zach's saying, I think the veto and the how much consent question are pretty closely related. Like I was saying earlier, if the goal needs to be consent and the process needs to be robust to get there. We've seen in BC where there was some consent, but not from all the three groups in that case. So I think there are going to be cases where there'll be some sort of measure on how much consent is needed, and I don't know what the answer to that is. But
I have a great follow-up question from online along that vein. So this question states that companies operationalizing consent requirements often leads to decisions about who constitutes the affected community and who the legitimate representatives are. This can have a political impact. Do you have advice for companies on understanding who to go to seek consent?
Okay. it's again not just a shameless plug for lawyers, but there's a legal, we're dealing with legal questions. There's a legal analysis to go through at the outset to figure out which nations have a claim or interest that could be impacted by your activity, and that then informs who should be consulted with, whether you're in a modern treaty context, whether you're in a historic treaty context, whether you're in an overlap area where there's both asserted rights and established. Those types of questions, you got to get a lawyer to help you think through. But you have to be open also to the reality that we're not just in an era of consent, we're in an era of nations reclaiming territory, reclaiming their authority and jurisdiction to make law according to their legal tradition in ways that can express itself midway through a project as a change to how a government makes decisions about consent, how it represents the rights holders that it's the constituent government of. So I think you have to be careful to be flexible, but a strategy that's flexible, rooted in the legal principles to make sure that you're consulting with, seeking consent from the rights holding community in a way that allows you to, if change happens midway through, accommodate legal processes that are rooted in Indigenous legal traditions around how consent happens and how representation should look.
So I'll go a level just below that. Once you've done that legal assessment, you've identified at a high level those legal requirements and the groups. I'm always surprised to see how sophisticated the non-Indigenous stakeholder mapping is done by proponents. Very sophisticated. We've got names of all the mayors, all of like the managing director of the local municipality, and then it's like the nation with like there's nothing in there. It's just a one block thing. Just get to know the Indigenous group, how they're organized, who are the leaders, who are the Economic Development Corporation, the business people involved in the community. Get to know the actual landscape. So the stakeholder mapping should be very similar in terms of the level of sophistication on the Indigenous side and on the non-Indigenous side.
Quickly to build off that, I think it's a similar point, but understanding that Indigenous context, understanding those governance systems is important, but I think it would be a mistake for a proponent to be going out and seeking consent from different groups within the community without a thorough understanding of those governance systems. Like it really shouldn't be the place for a proponent to determine who makes decisions. That you have to be very careful about that, I would say. So
we are unfortunately over time. We have a few more questions from online, but I don't think we'll have time to get to them. Thank you all for attending. This has been a wonderful conversation. It's a complex area, which is fun though, because I think we're all working through it right now. It's an area where everyone is having to be creative and flexible and try to think towards the future. And so I want to thank everyone for attending today, in person and online. Our next PDAC session is in a few short hours. It's at noon Eastern time, and the topic will be "The Earth is on Fire: What to Say and Not to Say." And Emilie will be joining that panel again, so you'll get a chance to hear more insight from her on essentially the greenwashing and green hushing issues. So please join us at that time. You can sign up for any of our upcoming webinars through our virtual calendar or by visiting the Fasken Institute section of fasken.com. So we hope you can join us for our next session and enjoy your PDAC.